This Honorable Court of Appeals of Tennessee is now in session.
Good morning, Council. Judge Bennett, Judge McBrayer, and I are thankful to be able to work with you today by Zoom so that your oral arguments can be live streamed for public viewing, not only as we conduct the argument, but that it will be posted on the administrative office of the court's website for viewing and consideration by the public and all interested parties at a later date. We will conduct the argument in the same manner as if all of us were together in the courtroom. Each side has 15 minutes, and I understand the appellant has already reserved up to 5 minutes with the clerk. And so unless there's some announcements, we will ask Mr. Hibner to call the case.
Michael Lee Brown versus Jennifer Karen Brown.
All right, we'll hear from the appellant.
Morning, Your Honors. Thank you for arranging this. The world changes every day.
Yes, it does.
So here we are doing it this way. I'm Dana McClendon. I represent the appellant in this case, Jennifer Brown. Ms. Brown and Mr. Brown, we're here on a custody determination. The parties essentially stipulated to a divorce and the property division. What we've got left is a custody case. The one child at issue in this case is Autumn Brown. Autumn was born October 24th, 2011. I think the facts are largely undisputed that at the time she was born, Miss Brown was a stay-at-home mom who spent the first 4 full years of Autumn's life as her primary caregiver. In 2014, February 2014, Mr. Brown decided that he did not want to be married anymore. He left. He separated from Miss Brown, and apparently at some point he was in the Army, was stationed then in Colorado, so he moved away. In 2015, Miss Brown unfortunately got a DUI, and it was at that point that Mr. Brown took temporary custody of Autumn and took her back to Colorado. She was there from late summer of 2015 until November of 2015 when she returned. Unfortunately, Ms. Brown had another alcohol-related incident, and it was at that time that Mr. Brown was recalled from Afghanistan, and he took primary custody of Autumn and maintained temporary custody of Autumn until from 2017 until the trial. The arithmetic on that works out about like this. It's clear that for the first half of Autumn's life, she was in the primary and often exclusive care of Mrs. Brown, and that in the 18 months before the trial, Autumn was primarily, but not exclusively, with Mr. Brown. Mr. Brown, during his parenting time, had a schedule that had some training events for him. It also sometimes required that he be away from home longer than just an ordinary day job might have required. He hired in a live-in nanny for $1,000 a month and delegated a lot of parenting responsibilities to the live-in nanny. So the court's conclusion was that Mr. Brown delegated a couple of hours, but it seems likely that it was more than that at times. This appeal comes to you essentially for a request that this court find that the evidence did not support the conclusions that the trial court reached. There were several. First, the trial court concluded that Miss Brown occasionally drank alcohol to excess, would black out, vomit on herself, defecate, and or urinate on herself. Even the father's allegation in that respect was that there were a handful of occasions that was disputed by Mrs. Brown. Mrs. Brown testified that she could recall less than what Mr. Brown said, but the trial court took what Mr. Brown said and came to the conclusion in paragraph 22 of the memorandum in order that mother drank to such excess on occasion. In fact, there were only a handful of occasions, and that's too many, but the court seemed to put a great deal of emphasis on words that suggest a larger number than even the father suggested. The court also came to the conclusion in
Well,
paragraph.
when she drank these incidences, you know, there were pretty serious incidences when she did it, though, right?
Well, she did have 2 DUIs and a public intoxication arrest. So
Didn't she have some children with her in at least one of those?
yes, on the second DUI, she had this Autumn, the child at issue here with her. And that's when Mr. Brown took temporary custody and took Autumn back.
Well, that's pretty darn serious, isn't it?
It is.
I mean, I don't think you can minimize the danger this woman put this child into, can you?
I certainly do not minimize the danger that the child was in that moment, and I certainly do not minimize the severity of the separate incidents. My criticism, respectful criticism of the trial court, was that the trial court's language suggests that that there were more instances, and there's another moment or another portion of this where the trial court speculates that there must have been far more, and there's nothing in the record to support the speculation that the trial court later engaged in. So I do not minimize what Ms. Brown did wrong. She did do wrong. I would add that Ms. Brown did seek appropriate treatment and counseling for what she had done wrong, and has done the best she can with what is fairly clearly a substance abuse problem that had plagued her for some time.
Is there any evidence that she successfully completed a treatment program?
There is, Your Honor. She was, well, as far as a treatment program goes, I know that in the record, she was evaluated by a team of, I don't want to overstate their qualifications, but I think there was a psychologist supervising someone who was also practicing in his office. And they came to the conclusion that that she did not pose a danger to the children. And even DCS came to the conclusion that she had completed all of her alcohol and drug assessment and successfully completed everything that DCS asked of her. And DCS at that time recommended reunification between mother and child.
Thank you.
Thank you.
Reunification as in primary residential parent, or is just as in visitation and custody for a week at a time or something?
Your Honor, what I will tell you is that in the record, the testimony from the DCS worker was that she passed all I'll read it to you. She passed all the drug screens, meaning Mrs. Brown. She completed the alcohol and drug assessment. She had ongoing therapy. So at the time I cannot recall whether or not it was at the adjudication point, but I did recommend for reunification and for the mom to return to the home. And the petition, the DNN petition at that point was dismissed.
Okay.
The trial court also came to the conclusion that that the father and mother had both had both appropriately provided medical care for the child. We dispute that. There is evidence in the record that the child had several times not received what was evidently needed as far as medical care when with the father. Perhaps the biggest problem in the case, and I'm running out of time, but I do want to address it, is that there were not one, but 2 instances of significantly inappropriate physical contact between the child while at the father's home and a older boy who was the father's girlfriend's son at the time. In the first instance, the father caught them. In the second instance, the father caught them and concealed it from the mother, and she did not discover that until later. The trial court did not seem to make much of the fact that the father had allowed the same child to perpetrate against the daughter, and then concealed it from the mother.
Where did the daughter learn about such activity?
Well, Your Honor, I'm going to take it on the chin. The record suggests that the child made disclosures that she had learned some of these play routines from a child in the mother's home. So I'm not going to run away from what the record says. I'm not sure that that's conclusively established, but the child did make the disclosure to that effect.
And remind me, what was the parenting time split here?
Oh, in the order that's been appealed?
Yes, yes.
Well, father lives far away. Father lives in Louisiana now. And so mother has
Right.
what I call the far, far away plan, which is parts of some holidays and significant part of the summer. But there is no every other weekend or anything like that.
Right. Yeah. I mean, there were 2 months on, 2 months off initially, correct?
Correct. And that, I'm not sure how durable that was, given that the child would enter school.
Right. She was in school age before. Yeah.
Right. To conclude, and I'll reserve anything else on rebuttal, but in a nutshell, I know I'm swimming upstream because of the standard of review that is in play here, but in a nutshell, it is our respectful opinion that the trial court overemphasized mother's flaws and mother's poor choices and ignored largely father's poor choices and the problems with creating a primary residential parent status for father. Thank you.
Thank you, Mr. McClendon, and we'll hear from you again on rebuttal, Ms. Brasher.
Good morning, Your Honors. The issue here, as Mr. McClendon has stated, is whether or not the evidence at trial preponderated against trial court's finding to adopt father's proposed parenting time or parenting plan. I apologize. In considering that issue, as Mr. McClendon kind of touched on, the standard of review for the appeals court is whether or not the trial court abused their discretion or exercised erroneous discretion. There's no evidence here that is the case decision. There is, in our opinion, no abuse of discretion. Another issue we'd like to point out to the court is the issue of credibility. A finding of credibility is important in giving deference to the trial court judge because she's the one that's there that can see the witnesses that are testifying and can make a determination as to credibility. The trial court judge in our case specifically found that father's testimony was credible. There were several instances of deceit on Miss Brown's behalf, both during the pendency of litigation and even just 4 months prior to the trial. She had actually pled guilty to a crime of dishonesty in filing a false police report. I believe she actually pled down to that to misuse of 911, but nonetheless still a crime of deceit, which calls into question her credibility completely. The trial court applied the best interest factors, which is undoubtedly the correct standard when determining the best interest of the child and entering a parenting plan. And that leaves us with the question of whether or not, based on all of these factors, the trial court reached a decision that's erroneous. At the beginning of the divorce and during the pendency of the divorce, Miss Brown had at least 3 criminal arrests or charges. First of which Mr. McClendon mentioned was the DUI in 2015, in which the minor child was in the vehicle with her. She had driven intoxicated to a Red Lobster, left the minor child in the vehicle, and went inside to the bar. She couldn't remember at the time of trial whether or not she had drank while she was at the bar. She did remember ordering a drink, but could not testify as whether or not she had been drinking. The second alcohol-related incident in 2017, she was again arrested for public intoxication, where she had driven with her second minor child, not the minor child at issue here, intoxicated to a gas station down the street from her house to replace the alcohol she had been drinking during the day while caring for her other minor child, leaving minor child at issue here at home alone when she got off the bus. Both of those alcohol-related incidences of Miss Brown required Mr. Brown to have an emergency return from his deployment with the Army to come and take custody of the child. Both of those incidents resulted in the minor child being in the care of the state for at least a period of days until Mr. Brown could return. Both of those incidences resulted in the minor child being determined to be dependent neglected. In trial court's memorandum and order, there is a detailed application of the best interest standard. Of the 15 factors applied, 10 were in father's favor, 2 were equal as to both parties, and 3 did not apply. The findings of fact and dispute that Mr. McClendon raised in his brief and also in his argument here, the first being that the finding that mother drank to such excess she would black out, vomit on herself, defecate, and or urinate on herself. Ms. Brown's claim is that both testimonies contradict this finding. However, father testified that mother's excessive drinking was frequent. The record reflects that he testified that it was at least 3 to 5 times per week, but that fortunately she had only defecated on herself a handful of times. Mr. McClendon even acknowledged in his argument that any amount of times was too many times for that excessive drinking. Another argument and a fact in dispute is that the child received medical and dental care with both parents. The court made a specific finding that there was no intentional failure to provide this care. And father's testimony showed he had taken the minor child for an annual well visit in October 2017 with no reported health issues, had taken her for another checkup approximately a month and a half prior to trial with no reported health issues, and had no serious reported health issues at any point during his parenting time. He had made efforts to provide the medical and dental care while the child was with him. There is an incident raised, the child involving a broken leg. Father's testimony was that the child had not complained of the pain and there was no apparent or obvious sign of serious injury that he was willfully neglecting to treat. It was also not even immediately apparent to Miss Brown. It wasn't until a day or two after she had picked up the child and the child had hit the injured leg on a bicycle or a tricycle, I believe, that even caused Miss Brown to take her into the doctor to have it checked out. Another issue that Miss Brown claims that she's been more of the primary parent due to Mr. Brown's deployments and his work schedule. Certainly it's undisputed that from the time of birth until the child was approximately 4 years old and the parties separated, that Miss Brown was in fact the primary caregiver while Mr. Brown is at work and while he's deployed. Certainly when he was home from work, he was helping with those activities. And also when Miss Brown was the primary parent while Mr. Brown is on deployments, that resulted in at least 2 occasions where Mr. Brown had to return early from these deployments as a result of the child being taken into DCS custody based on Miss Brown's arrests. When Miss Brown was the only parent, as she claims, the child suffered being removed from the home twice based on her actions and being determined to be dependent neglected twice while under her care. Even after the 2015 and 2017 arrests, Miss Brown was again arrested and charged with criminal activity in 2018. Her actions clearly show she's not capable of providing a stable environment for the minor child, which the trial court certainly took into consideration. Mr. Brown's testimony showed that he developed a consistent routine for the child. He takes her to school every day, arrives home by 5 p.m., is able to care for the child, engages in regular weekend activities with the child. The argument and the claim that Mr. Brown was forced to hire a live-in nanny because he's not capable of providing full-time care is inaccurate. As stated, Mr. Brown utilized the services of the live-in nanny a couple of hours a day. There is a chance with his employment that he may have late night trainings on occasion. Prior to trial, in the last month or 2 months leading up to trial, that had happened on 1 occasion. It is not a regular occurrence that Mr. Brown acted out of an abundance of caution to ensure that if it did happen, he had a plan in place. He was being a responsible parent to make sure this minor child was being cared for. With respect to past and potential future of parenting responsibilities and willingness to co-parent, the court specifically found that neither party was guilty of intentionally denying parenting time to the other. There was a claim when the parties were operating on the 2-month on, 2-month off parenting schedule that Mr. Brown had intentionally denied Ms. Brown parenting time. The court specifically found and acknowledged that order that entered the 2-month on, 2-month off parenting time allowed for flexibility with Mr. Brown's training and work schedule. Ms. Brown claims that father's decision or Mr. Brown's decision to deny her parenting time was because he was able to capitalize upon her mistakes. Ms. Brown's own actions are what resulted in the child being removed from her home by DCS on at least 2 occasions. And Ms. Brown also claims that she's taken these steps and gone to treatment to control and get her alcohol issues under control. However, even after there was an order put in place by the court in 2016 that prohibited her from consuming alcohol at any time, she ignored the court order, continued to drink alcohol, admitted so. There's also a court order in 2016 that required her to maintain an interlock device in her car. She ignored that as well, which resulted in her 2017 arrest, where she had driven drunk to the gas station to replace the alcohol she had just consumed during the day. The issue with respect to the minor child in Mr. Brown's home that had resulted in some issue of sexual abuse, the record is clear that the minor child disclosed that she had learned of this behavior from the stepchild that is still present in Miss Brown's home. It's inaccurate to state that Mr. Brown attempted to cover this up or to prevent her from knowing about this. He immediately reported it, took the minor child to a therapist to address the issue, and it implemented safety protocols in his house to prevent any sort of incident from occurring again. To claim that he attempted to cover this up is just another attempt of Mother or Miss Brown to deceive the court and twist the story to fit her narrative. The minor child at issue in Mr. Brown's home that had been the aggressor with the sexual abuse is no longer present in Mr. Brown's home. He's not at risk to being back in the home. The minor child in Miss Brown's home is still there. She's actually married that child's father and is now the step sibling, and it is anticipated he will be there for the foreseeable future. Miss Brown had claimed that she had successfully implemented safety protocols to prevent any incidences between the stepchild and her home and
Ms. Brasher, I don't know if you can hear me, but I'm afraid you've lost connection. I can see you can't hear what you're saying.
Since 2017.
Ms. Brasher, can you hear me? I'm afraid we've lost connectivity with Ms. Brasher. Mr. Hibner, can you call her?
And Your Honor, I went ahead and
I
stopped.
can.
Oh,
Okay, there you are, Ms. Brasher. For about a minute,
Okay.
we have not been able to hear you. We heard very garbled words, so obviously there was a connectivity problem. So if you can if you wish to, if you can reconstruct what you said in the last minute, we're all ears.
Okay. I'm not sure where that would have left off.
Well,
I will go.
The last I heard was you said there is no competent evidence that there were 2 incidents where father covered up the first one of the child, and that the that other child is now married and grown or gone out of the house or something, and is no risk of that child coming back into the father's life.
Okay. Thank you. Yes, the second incident with the minor child in Mr. Brown's home that Mr. McClendon indicated or argued that Mr. Brown had intentionally covered up this act. That's an inaccurate statement. Mr. Brown, while he may not have immediately reported the incident to Mother or to Miss Brown, he did report the incident to the proper authorities and took the minor child in to a therapist to explore the issue and find out exactly what was happening. Mr. Brown had immediately implemented safety protocols. He had not immediately reported to Miss Brown as a result of the first incident when he had discussed it with her. She had not taken any appropriate action. In his opinion, there was no risk that the minor child at that point was going to be in the presence of Miss Brown's residence or that other minor child, the step sibling in Miss Brown's residence. And he had acknowledged that that was a mistake, that he had not immediately told her, but to claim he had covered it up is an inaccurate portrayal of that instance. The minor child who had been the aggressor in Mr. Brown's home is no longer present in the home. There is no risk that he will be back in the home. That was a child that lived with them in Colorado. Mr. Brown now lives in Louisiana. That minor child is not in the home. The elder step sibling who had been the aggressor in Miss Brown's home, however, is still in the residence. Miss Brown has married his father. That child is now officially the minor child's step sibling and will anticipated to be there for the foreseeable future. Mother had argued at trial that she had successfully implemented safety protocols to prevent any additional incidences between the two children. However, that's also inaccurate to claim that she had successfully implemented those, because the elder minor child in Miss Brown's residence had not been permitted to be in Miss Brown's home while the minor child was there since at least 2017. So we believe that based on all of the facts and the evidence presented at trial and father's credibility and mother's issues with credibility, that the facts did not preponderate against the trial court's findings, and that the adoption of Mr. Brown's parenting plan should be upheld. Thank you.
All right, thank you, Ms. Brasher, and I heard you very well during that last segment. All right, Mr. McClendon, you have time for rebuttal. Be sure to unmute. Okay.
Thank you, Your Honor. I don't want to, I think the court is going to have to just go through this record carefully. I'm not going to take, 5 minutes wouldn't be enough to go through and argue tit for tat, all of these things. I think the general thrust of the argument that we have here is that the court, in every case, overstated, with all due respect, mother's wrongdoings and understated fathers. And we think that there are, as I've outlined in my brief, a number of examples of that where the trial court was punitive or speculative in its findings, and we would ask the court to vacate the order of the trial court and remand with instructions to enter mother's parenting plan. Thank you.
Thank you, Mr. McClendon and Ms. Brasher, for your arguments. We will take the case under advisement. Mr. Hibner. You're muted, Mr. Hibner. There we go.
It's been one of those days.
This honorable court is now in recess until 1 p.m.
Thank you, Mr. Hibner.